All right, so why don't we kick it off, everyone? We've got our members and our guests and our colleagues piling in. So, very good day to you all. Welcome and hello. Thank you for joining the Wall Street Blockchain Alliance's latest public event. The SEC strikes again. In a recent enforcement action, the U.S. Securities and Exchange Commission alleged for the first time that 9 tokens involved in an insider trading scheme were securities. So this session will be a conversation with leading legal and industry experts to discuss the implications of the SEC's latest actions, in this case, the reasons behind them, and their potential impact on the crypto world. Before we begin, a bit of housekeeping for today's session. This webinar is being recorded. All attendees will be in listen-only mode. Attendees are encouraged to submit questions using the Zoom Q&A function. We'll be doing those and reviewing throughout. We'll have question and answer at the end of the session. Please do keep in mind that this event is offered for general information and educational purposes only, and is not intended to constitute investment, legal, tax, or accounting advice. Josh is laughing because I know a lot of lawyers and accountants. And again, also keep in mind that any views or opinions expressed during this event are those of the participants, do not necessarily reflect the views of the Wall Street Blockchain Alliance or our participants' firms. So with that, I think we have all of our attendees starting to pile in. Great to see you all. Welcome. Let's do a little bit of introductions and disclaimers. Sam, why don't we kick off with you and tell us who you are. Tell us what you do.
Sam Enzer, nice to meet everyone. I'm counsel at Cahill, Gordon, and Reindel in our cryptocurrency enforcement defense group, where I focus on defending companies and individuals in white-collar matters. I used to be a federal prosecutor in the Southern District of New York in the Securities and Commodities Fraud Unit, where I used to work with the SEC and the CFTC in parallel on cryptocurrency matters. And we're going to be talking about some of the matters that they just charged as cases last week.
Sam, thanks. I'm going clockwise around at least my screen. Kayvon, how about you next?
Sure, thank you. My name is Kayvon Sedeghi. I'm a partner at Jenner & Block here in New York, and I lead our blockchain and digital assets practice. I've been a lawyer for about 20 years, focused on things like securities litigation and SEC investigations and other enforcement activity, and have been in the blockchain space for, I guess, a little over 5 years now, and excited to be here with everyone.
It just feels like 20, right, Kayvon?
Exactly.
Mr. Johnson, how are you, sir?
Hi, Ron. Thanks for letting me participate in this. My name is Richard Johnson. I'm the founder and CEO of Texture Capital. We're a digital asset securities broker-dealer, although maybe I should start calling myself a crypto asset securities broker-dealer after the action last week. We're regulated by FINRA and the SEC. We help clients issue tokens compliantly, representing equity, debt, royalties, revenue share, and so on. And we have an ATS, alternative trading system, for secondary trading of these security tokens. I've been in the crypto blockchain space since about 2014. And before that, I spent about 14 years on Wall Street working on a few different trading desks.
Good to see you, old friends. My old friend, Joshua Klayman.
Hi, thanks. Great to be here and to see everyone. I'm Josh. I wear a lot of hats. One of my favorite hats is that I get to work with our amazing panelists and Ron as part of the Wall Street Blockchain Alliance Legal Working Group. And beyond that, I'm Senior Counsel and U.S. Head of Fintech and Head of Blockchain and Digital Assets at Linklaters, which is a global law firm. At Linklaters, I work on a wide variety of digital asset matters, often including those before the SEC's FinHub.
Josh also sits on our board of directors, which is why I have to be nice to her on all of these webinars, everyone. And finally, Mr. Gottlieb, great to see you, my friend.
Good to see you. And we're all nice to Josh all the time anyway, because she deserves it. I am a partner at Morrison Cohen in New York. I chair our white collar and regulatory enforcement practice group. And I also head up our informal digital assets group, where we deal with crypto, blockchain, and Web3 issues. I'm a litigator by trade, much like Kayvon. I have a litigation and enforcement background. So these days, about 50% of my time is doing crypto enforcement, dealing with SEC, CFTC, DOJ, states, and other agencies. About 50% of it is litigation, just general commercial litigation in the crypto space. About 50% of it is advisory, and the other 25% is math lessons.
Thank you all for being here. It's a great privilege. Let's start with that kind of kickoff question. And we tend, you all know, to make these very conversational, but Sam, let's start with you and then open it up to the rest of the panel. I want to start by describing the recent SEC DOJ action. It involved the arrest of a Coinbase employee, I believe, and 2 others involved in insider trading. I'll state out there, at least from my perspective, there seems to be a lot of misinformation or misunderstanding about what happened, particularly in the Twitter sphere. So what were those circumstances? When did the alleged insider trading occur? And why is this important in context?
Sure. So the scheme, or the alleged scheme, is very simple. A former Coinbase employee was charged along with 2 associates based on allegations that the former Coinbase employee, when he worked at Coinbase, had access to confidential information about which cryptocurrency tokens would be listed, which could be market moving ahead of time, and that he shared this information with the 2 associates, and that they traded on it to their profit in breach of the former Coinbase employee's duties to his employer. So it's a simple, those allegations are simple and straightforward. And the allegation is that the trading based on the illegally obtained inside information resulted in trades in, I think, approximately 25 tokens. The Department of Justice, the Southern District of New York, my former office, charged the 3 individuals involved with wire fraud charges, conspiracy and substantive wire fraud, alleging that they committed these crimes, and did not characterize any of the tokens as securities, and did not charge a securities fraud charge, even though the case is being handled by the securities fraud unit. The SEC, in contrast, brought a civil complaint in Washington, in Seattle, Washington, alleging that the scheme described here, that these 3 individuals engaged in conduct that constituted securities fraud, the form of securities fraud characterized as insider trading, and that 9 of the 25 tokens at issue, according to the SEC, were securities. Why is this significant? There are a variety of reasons why this is significant beyond the stakes for the 3 individuals who are now accused of these very serious charges. So one issue for the entire industry here is, if in fact these 9 tokens are securities, then exchanges, digital asset exchanges that allow trading on them, in the SEC's view, may be operating as unregistered national securities exchanges in violation of the securities laws. Another issue is that Coinbase was cooperating in this investigation. According to the press releases issued by the Department of Justice and by the U.S. Attorney's Office, there are statements that Coinbase was cooperating, and yet, according to public statements by Coinbase, it appears that the SEC, without dialogue or prior notice to Coinbase, characterized these tokens as securities, notwithstanding their cooperation, without giving them an opportunity to be heard on that issue. And it has significant implications for Coinbase, for other digital asset exchanges, for the issuers of these tokens, for people who hold the assets. And then another one of the big issues that I think some of the other panelists are going to talk about is, historically, in SEC enforcement actions alleging that tokens are securities under the Howey test, there was a stream of cases that characterized token offerings, initial coin offerings, as securities offerings under Howey. Here, the coins, the tokens, all or virtually all of them, they're not being alleged to be securities as part of an ICO, but rather in the secondary market, which is a dramatic expansion of the SEC's position on what is or is not a securities offering. Is it the token or the offering? Those are some of the issues. There are others that I think we'll talk about.
Sam, thanks. I want to pull Kayvon and Josh. I want to pull you into this conversation and peel back the layers there. The commentary involving the 9 tokens as opposed to the dozens of others traded on Coinbase. When colleagues in industry said, "Well, why?" The simple response seems to be Howey test. Can you peel back the layers of that a little bit? Why only those 9? It almost feels like there would have been others, but there was no time. And if Coinbase was sharing this information, why is that 9 relevant? Why is the industry hooked onto those 9? And what do we need to understand about that? And is there a path back to compliance for those, or are they totally unregistered securities, and that's it. Kayvon, let's start with you if we could.
Sure, and I think you raised one, both of the questions that are really relevant here that people are asking, and we get the same questions, which is why these 9? What is it about these? And sort of more broadly, what impact does it have that you're calling these 9 tokens securities more broadly? How is this different than all of the prior ICO cases? There's a lot of media attention on this, and so the question is, why is this different? We look at the analysis and the complaint of those 9 tokens, and it looks a lot like the same Howey analysis we've seen in all the ICO cases before. They going through the typical prongs of Howey. So what's important about this? And I think there are a couple important issues for framing why the 9 tokens. It's important to note that the SEC's complaint mentions that there are 25 tokens that were traded by these 3, and then it only walks through 9 of them to allege those 9 are securities. It doesn't say the other 16 are not. It doesn't say they are. It just walks through 9. So you may be right that it has something to do with the timing. We've looked, I know others have looked at the 9 that were chosen, and it's not clear that there's any particular common thread for those as compared to other tokens. It's not that they're all US based, because they're not. It's not that it's a particular type of token, because these tokens sort of run a spectrum of tokens from functional to pre-functional, governance tokens, tokens with utility. There's no particular pattern that we see there. And it doesn't seem like there's any correlation to the timing of the issuances or anything like that. So the question is, what is it about these 9? And it may be that it has something to do with timing or something else. The 2 allegations that I think we see consistently about these 9 are that there are indications that the core team is still involved in the project and has an important role in the project to this day, and that there were efforts to promote the secondary market for the tokens and the listing for the tokens. Those seem to be consistent, but it's not clear that either of those things distinguishes these 9 from the other 16. These 9 may have that in common, but the others may also.
Josh, do you want to weigh in?
Sure. And I'd like to build on something that Kayvon mentioned about there not necessarily being a pattern. Now, we certainly don't know what is in the mind of the SEC or what may have been in the mind of the SEC or its various people at the SEC. But often, if we look back at SEC enforcement actions in the digital asset space, they've kind of tried to build on one another, to have some kind of teachable point to them. So it could be that the lack of a pattern is intentional, right? It could be that they're trying to say, look, you can have digital assets that do this, that were sold this way, that are being, that this is happening, and we're still going to allege that there is an investment contract. And so maybe the lack of a pattern could be meaningful. Again, we don't really know. I think another thing, and I haven't looked into this, and certainly others may have or may know, but for the tokens that are alleged to have been sold as securities, it's possible that there may be indicia that they were sold pursuant to an exemption, or there may have been some public statement made in some filing that may give a better foothold, or to a greater or lesser extent, for certain tokens, at least for the initial issuance. Now, I think an interesting question that I'm sure we'll probably get to later is whether, irrespective of whether something was offered and sold as a security, at the time when this action was taking place and at the time of the listing, was it still a security? Because definitely this idea that you could retest at a later time, particularly if you have satisfied the 9 factors in the April 2019 framework that go to decentralization, I think that's something to consider as well.
Josh, go ahead.
I was going to say that Josh just raised the other point that Sam had alluded to too, that I know we were going to get to next, which is really what's different about this case as compared to everything prior in the ICO issuance cases is the focus on the tokens themselves as securities as compared to the circumstances in which they were sold, being a securities offering. And that's a really important distinction for a number of reasons. I think we probably need to unpack that a little bit because when you look at what the definition of a security is, there's a list in the securities laws of a number of things that we usually think of as a security: a stock, a bond, a note, things like that, almost all of which are an instrument that reflects some obligation from the issuer to whoever's purchasing it. And that can be traded and the obligation goes with it. But those are all instruments that, it carry some sort of obligation or rights, et cetera. Then there's this catch-all category that we all have gotten to know with Howey of an investment contract. And Howey is a recognition that you could create an investment scheme around anything. In Howey, it was interested in orange grove. This has been used for whiskey barrels and beaver skins and all sorts of things over the years, because you can create a securities offering around everything. But that doesn't mean that the thing that you are creating a securities offering around is itself a security. In fact, in most of these instances, the reason you need that investment contract analysis, that Howey analysis, is because the thing at the center is not a security, and you've created an investment transaction or scheme around something that is not one of the typical instruments that you would think of as a security. That's sort of the purpose of this test. And so the test inherently looks at the circumstances in which something is sold or the scheme around it. That's the design of the test, and it looks for an investment of money with an expectation of profit based on the work of others and a common enterprise. And the common enterprise piece is key here, and there's some disagreement as to exactly what that element means. But the prior ICO cases, this distinction didn't particularly matter to whether or not there was a violation, because they were going after the issuer. So the issuer selling the tokens in an ICO or a SAFT or what have you, that there was an issuance, and that would be a securities offering, whether or not the token was a security itself necessarily. Whereas here, we're dealing with insider trading, securities fraud theories where the issuer is not a party. These are transactions in a secondary market with no privity to the issuer at all. And so these claims only work if the token itself is a security. So it actually puts that issue directly before the court in a way that it hasn't been before. And that's a key distinction.
Kayvon, thanks. And obviously for the audience members and who are joining us, please start submitting your questions via the Q&A. Jason, let's pull you into this conversation. And then Kayvon's point really neatly segues us into something we've been talking about. The crypto complaint targets the individuals. And again, I use this phrase misinformation. There was a lot of consternation on Twitter and beyond around, well, how come they're going after the individual versus Coinbase? Noting that the SEC should have or could have targeted the exchange for listing and trading unregistered securities. What is that true? And why is the SEC approaching it in this particular way?
Well, I think that's really more of a question for the SEC. By necessary implication, if these tokens are securities, then the SEC is alleging that Coinbase has been allowing the trading of securities, and Coinbase is not a registered securities exchange. So, in a way, this is a shot across the bow at Coinbase. Chair Gensler has previously said on numerous occasions, whether or not specifically naming Coinbase, that there are a lot of exchanges that are trading lots of securities without being registered. And, I think the market has reacted to that. I mean, just since this case came out, Coinbase stock is down 20%. I think that there is a broader lesson in this. I think that it suggests that the SEC's actions are having a broader impact, even beyond just the impact on these three individuals. I looked as well at the impact on the particular tokens. You can look up all their prices on CoinMarketCap. And when we looked at all of them, we found that from just before the filing of these complaints to today, just to take a sort of arbitrary cutoff, all these tokens are down an average of 8%. Now, a couple of them actually went up, so who knows? And of course, there are all sorts of confounding theories, right? It's possible that their values would have gone down even more sharply if not for, et cetera, et cetera. But what this calls to our mind is the SEC's action has broader impacts and effects. So we could talk about the broader a little bit later in the discussion, but just sort of immediately when the SEC comes out and says, we think that these tokens are securities, and we think that by necessary implication, Coinbase has been trading in unregistered securities or allowing those to trade on its platform, you have questions about whether exchanges are supposed to delist these tokens if they're trading them now. You have questions about whether companies can be doing deals with these tokens that where the deal's nature would be changed if the token was a security. And what all of this is going to lead to is less liquidity in these tokens, less people dealing with the tokens. There's going to be fear of enforcement hanging over Coinbase and over all of these projects. And it has an immediate market impact. And I don't know if that was in the SEC's mind or not, if they set out to do that deliberately, or they just said, we're just going to file this action and consequences be damned. But I think all of those are very good questions for the SEC. I understand that we have a few folks from the commission on the call. So hi, everyone.
Jason, thanks. Sam, did you want to add to that? I know you and I, that was part of the conversation we had in prep as well. Any thoughts?
Yeah, sure. I would say a couple things. I think what's troubling or concerning about the way that the SEC proceeded here to the market is because the question of classification is so significant for Coinbase and for the issuers, it seems unfair to raise that issue in a court case to which none of them is a party. And you have to remember here, the Department of Justice has already brought criminal charges and will prosecute these three people for their alleged crimes. And so the law enforcement interest is taken care of. Bringing this case, I'm not sure what interest of the SEC it indicates. It is likely to be stayed because it is typical in parallel proceedings for the Department of Justice to move to stay the civil case while the criminal case plays out, which means you've basically got an allegation out there from the regulator that these are securities, and the parties with the greatest incentive and the resources to defend the other side of that are not parties to the case, may not be able to get into the case. I see one question is, can the issuers, can they intervene? And I think that's a very good question. I believe Rule 24 under the Federal Rules of Civil Procedure is the relevant rule, permissive and mandatory intervention. And I think that's going to be an interesting question, whether Coinbase or some of the issuers try to intervene. In the Ripple case, the SEC's case against Ripple, investors tried to intervene. They were denied that opportunity, but given the opportunity to file sort of an amicus from the judge. The circumstances here are different, though. You could see in a situation where you have investors and there's thousands and thousands of investors, a judge may not want to let all of them in. But here, the parties with an interest who are not in the case, Coinbase and the 9 issuers, it's a discrete group. And so, how that plays out in court would be interesting if some of those folks try to intervene.
May I?
Please.
One of the things that came up last April 2021, was there were headlines saying that Coinbase had amassed a $4 billion regulatory war chest, right? So definitely when we see the SEC having recent repeated requests for additional funding for enforcement and trying to expand the team, one could imagine as well that, rather than entering into a similar large scale war, really, as is the case with the Ripple litigation, that this would be sort of a strategic move potentially to avoid that $4 billion regulatory war chest on the other side.
Thank you, Josh. Thank you all. I want to throw this out for the group simply because I didn't note who I should be asking this question first, so my apologies. But we've had a lot of colleagues in the crypto industry at large really see if there's an inference that can be made around jurisdiction. Let's educate the audience, educate me, certainly. It was brought up in the Seattle jurisdiction. Is there any inferences we can make about that? Is this a way that for the SEC to be looking to make precedent in court through this? Can someone speak to jurisdiction broadly?
Happy to try.
Yeah, go for it, Sam.
I think what you're referring to here is venue, where a case is venued. And here, the Southern District of New York filed criminal charges in the Southern District of New York. And given that the criminal authority has to prove their charges beyond a reasonable doubt and venue by preponderance, we can be confident that they feel there's strong evidence to venue the case there. So then the question is, why did the SEC venue this case in Washington. It's possible to have a case can be venued in more than one jurisdiction if there is a factual basis to do that. There are different possible inferences. So one possible inference is typically the New York regional office of the SEC you see working with the Southern District of New York Criminal Authority. And so it's unusual for a different office of the SEC to be handling a matter when the Southern District of New York is on it. That could mean that the Washington office of the SEC opened this matter first, and then they just chose to file it there because it's their home court. It's more convenient and efficient for them. That could be it. Could be that they reviewed the law and they're engaging in case law arbitrage. They're looking at a jurisdiction that they think will be more favorable. The Southern District of New York is in the Second Circuit, probably the most sophisticated circuit in the country on questions of securities law. And perhaps they thought they would get a more favorable audience in the Ninth Circuit, but that's speculation.
Thank you, Sam. Jason, Kayvon, as litigators, anything you want to add to that?
Yeah, I mean, I don't know that it has any particular based on where they filed here. I mean, the defendants were in Seattle, at least, a couple of key people were in Seattle. So that's an obvious reason to go there. I agree that disjuncture between that and the, prosecution in New York is certainly noteworthy, and the Second Circuit question is interesting. One other factor that might be relevant there is there have been a couple cases in the Southern District of New York, so there are some, there is some precedent here and some federal judges who have considered these issues in the Kit case and the Telegram case. And in particular, the Telegram case, there were specific arguments in that case around whether the Graham token itself was a security or not. And Judge Castell, made pretty clear in his two opinions, there's an initial opinion and a sort of follow-on opinion, made pretty clear that the Graham token was not the security, that the security was the overall scheme, but not the Graham token itself. Now, if that logic were followed, that would be problematic for the SEC here, and I'm sure that's going to be an issue that's raised as this gets litigated, but it may be, preferable not to, take on and disagree with Judge Castell's logic, in the Southern District.
I would never disagree with Judge Castell. He's a Cahill alum.
Thank you, Kayvon. Thank you, Sam. Richard, let's bring you in here. Let's mix up the agenda a little bit. Coinbase recently noted in a public blog that the current rules, current ways of regulating, and there's this oft-used phrase in industry, it says regulation by enforcement. We'll come back to that in a bit. But from the perspective of financial markets participants like you and I have been in our careers, what does this recent action do to kind of current and future plans in this space? What does that strategy look like for you and others going forward? And the one question I want to ask for everyone here as well is, why is there such resistance in the crypto industry to registration with the SEC? The chairman makes that invitation all the time. But Richard, let's start with you and then expand that out to the rest of the group as well.
Yeah, thanks, Ron. Well, I mean, stepping back a little bit, in a way, this shouldn't really be too much of a surprise if you look at what the SEC has been saying for the last 5 years. It was 2018 when Jay Clayton came out after the ICO, in the middle of the ICO boom, saying every ICO is seen as a security and that these platforms should be regulated. That was, in fact, the kind of light bulb moment, the call to arms for us to set up Texture as a regulated intermediary to launch security tokens compliantly with the rules. And then, of course, Gary Gensler has been saying for, since he got there, essentially that, some or most of these tokens are securities. And I think the industry was saying, okay, well, which ones? Explain your thinking. And he never did. He would say, come in and talk to us and so forth. So the difference here, and I think why this is so newsworthy and so interesting to us in the space, is that it is the first time he's gone out and he started naming some securities as some tokens as securities. So in terms of us, our strategy, I mean, this is what we built the company for. As I said, we can issue security tokens that represent security that are, a common enterprise with an expectation of profits and an investment of money and the efforts of others. All the Howey test things. It's a security. We can help you issue that as an issuer, and we can help investors trade that as well. Certainly. we would have liked to see more clarity and I think more openness, from the regulators to get to this point a bit sooner and to develop a more workable framework. One of the things that the Coinbase blog says is that digital asset securities regulation is unworkable. It's not completely unworkable. Like, we have a working business model. We participate in a number of security token offerings and so forth. But there are constraints to it. You need to have, a transfer agent in place. And of course, you need to, if we're issuing the token in the US, then we can sell it to US investors. That doesn't mean that, it's going to be tradable, in any other jurisdiction. It would presumably have to follow the securities rules, in those jurisdictions. There's other constraints that you have if you're doing security tokens. So like a compliant security token. So you can issue it under Reg D, but then you can only sell to accredited investors. Most of the crypto market is retail, to be fair. And the other thing, if you issue it under Regulation D, is that there's a 1-year holding period before there's any liquidity. That's kind of a non-starter for a lot of folks in the crypto space. Well, the other options are a registered offering, like a full S1. And a couple of companies have done that. And, I think literally only 2, INX and Arca, and they got through it, but it was certainly, expensive and very, very, very time consuming. There is a new avenue coming up now, which is Reg A, which is is technically an exemption to registration, but it allows you to raise a limited amount of capital from retail investors up to $75 million in a year. And that was much harder, I think, but some ground has been broken there. There were some high profile companies that filed Reg A security token offerings, such as Blockstack and Props and a couple of others. And now I think given the guidance that we have from the SEC, I'm talking about the joint statement, the 3-step process, and some of this other prior work. There is a path for a lot of for companies who wish to issue compliantly tokens that are securities, essentially. Still, the things that you can't do, the bits that are unworkable, are things like, well, for example, having it trade globally 24/7 on day one. That's just a constraint of securities regulations. Things like using the security token for staking in some kind of proof of stake model or something is very difficult under these rules. And using it as a payment leg or as a payment rail, so you're participating in the network and you get paid in the token. That'd be a difficult thing to do compliantly under securities regulations. So I think potentially one solution that we haven't talked about yet, but was also mentioned in the Coinbase petition for rulemaking, which is like I think it's a 32-page document or something like that, is can we give a definition of, one path you could have is where, and this was kind of the Hinman speech where he spoke about Ethereum and said, well, Ethereum started off as a security because it was a crowd sale basically, and then it evolved into becoming a non-security token. So I think that could be a path forward for some folks wishing to do tokens where, yes, they need to raise capital to build a network, to hire developers, to build the layer 1 or the layer 2 or whatever it is. That's a security. And then perhaps after a period of time, if there was a way to define, when that could be compliantly, it could transition to being, a more of a utility type token.
Richard, thanks. I want to give the opportunity for anyone else in the panel to comment on that. And I'm certainly waiting for someone to define sufficiently decentralized, but let's open that up to the group as well.
Can I amplify Richard's comments? Sorry, I think Richard's making a really good point here when he goes through all the paths that one could take to issue securities. I think the SEC has not provided a path to issue tokens that mix actual utility within a network and a traditional securities status, a traditional framework. Like, there isn't one. Lots of startups issue stock. There's plenty of pink sheets out there. Issuing stock, raising equity through stock is well worn. Everyone knows how to do that, and plenty of companies can. But what we haven't seen is a sort of curiosity. The SEC is not asking, why aren't crypto companies complying? Why are there all these tokens out there? Is it just that they're all scofflaws? And the answer is no, they're not all scofflaws. Most of these folks really want to be compliant, but there is literally no pre-approved path, no path available to offering something that may have some features of a security, but mostly has utility within a network. It seems like if there's sort of one drop of securityness to it, then the SEC is going to think that it's a security. And all these paths that we've talked about, that Richard just talked about, are all not really feasible. S1s are not feasible for any except the very largest. Reg D has all of the Rule 144 problems after that year lockup. Reg A requires pre-approval, and very few companies have even bothered trying, much less gotten approved. And more important, as Richard said, if you're offering a security, you can just offer a security. That's easy. But offering a security that is also a token that has these uses, it sort of undermines the whole purpose of offering crypto tokens in the first place. So there's no good path to do this. And when there is no good path to do it, what the SEC's actions and what actions like this are doing is forcing more people either to obey all the securities laws, just issue plain equity and forget about any kind of experimentation with the tokens. But that's going to drive things offshore. If people are going to do it, they do it offshore. They do it in purely decentralized, largely anonymous ways sometimes. We can talk about what decentralized means separately, Ron. But if there's no path to doing it the right way, people will do it in ways that the SEC may not like. And the net effect of this, and this is the broader effects of these actions that I said we'd come back to and talk about now, is less investor protection. If one of the purposes is to protect investors, we have to give people a way to play within a system that will protect investors. If we don't, then people will play outside the system. And then if there are rug pulls, if there are hacks, if there are other issues, there's nothing that can be done about it. The US authorities are largely powerless to deal with it. So, if we want to protect investors, we have to pull things within, and this sort of scattershot regulation by enforcement is having the opposite effect of what the SEC would like to do. And in this case, it's not even regulation by enforcement. I know Enforcement Director Graywall keeps insisting they don't do regulation by enforcement, but this is classic regulation by enforcement, but it's regulation by enforcement against other people. As Sam said, there's going to be no opportunity for these companies to come in and say, no, you're wrong. They can't challenge this. Case is most likely going to be stayed. Most of these cases are going to end up in a plea agreement or a settlement. So all of the immediate impacts that we talked about have no real way to be ameliorated. This is the impact of these cases, both the immediate impact and the broader impact. And I have to question, again, hi to my SEC friends who are watching this. I have to question if this is really serving the core purpose, the mission of the SEC.
Jason, thanks. Josh, go ahead. I know you wanted to chime in there as well.
Thanks, and I agree with the points that have been made. I think looking at things slightly differently, I do think that there are ways, notwithstanding the friction that may be involved if you have a consumptive token and complying with certain requirements. But I do think from a communications, disclosure, and other perspective, there are ways to comply with the securities laws, even if you have a consumptive token. I think, Ron, to your question about why aren't people registering, I see two major things. One is if you are a token issuer, right, and you are going to come out and say, I'm selling a security token, right? One of your first things is if you want to have a US market, you say, where will it trade? And then you look around at any place that would have sufficient liquidity. And at the moment, there, in terms of ATSs, yes, there are some ATSs out there, but when you look at the liquidity versus, say, the major trading platforms that are not ATSs for tokens, it's not comparable. So I think just from a company perspective, that's one of the calculations that goes into it. I think on the other hand, when we think about, well, why would trading platforms, aka exchanges, why would they not register, or why would they not try to become an ATS? And I think one of the challenges is it's very easy to say, okay, we'll solve all the problems by having these digital asset trading platforms become ATSs. But if you follow the logic that, at least in the SEC's view, many of the digital assets offered and sold have been illegally sold as securities, potentially, then an ATS may not be able to list it anyway, right? Because it may not be able to fulfill its diligence requirement.
Right.
And so I think that that's one of the pieces, unless there's a way to kind of rehabilitate the market, or I just think that that is a piece of resistance, because there really doesn't seem to be a clear path forward for what happens to the many tokens that are already out there.
Yeah, I think Josh makes a good point there, because I think about that as well. What if we could bring one of these tokens onto our ATS? What would we have to do? We'd have to go through a due diligence process. We'd have to get financials from the issuer. We'd have to get an org chart, these types of things, like an offering memorandum, and they just don't exist. So I'm wondering, and I'm going to ask a question here, throw it out to the group. In addition to this, I said earlier, I think that this action by the SEC is a bit of a sea change, Nick calling out tokens for the first time. The other thing I've noticed recently is that Gary Gensler started using the word exemptive relief. He says, I have the power to give exemptive relief, customized relief to certain tokens and offerings. So I'm wondering, is anyone pursuing that? To me, that sounds like there's a little bit of room for flexibility here. And, for example, maybe for some of these tokens that were issued as securities, there could be some other form of guidance where there's different types of disclosures that a regulated ATS could make to customers. I'd like to hear what everyone else thinks.
And Richard, to that point, what does the chairman mean by tailored exemptive relief? What does that look like?
So yeah, I can jump in here for a little bit, and I think that the issues that everybody's addressed, I agree with completely. I think one of the difficulties with the come in and register, to have a discussion of the exemptive relief, I think there's a general feeling in the market that is not entirely unwarranted, that if you actually take the SEC up on the offer to come talk to them, it is not incredibly likely that you are going to be given any sort of clarity or comfort that you're on a path that's acceptable, but you are somewhat likely to get a subpoena or be subject to an enforcement action because you're on their radar and you may not really have been before. And so I think, when people raise that risk, it's hard to disabuse them of that concern, because they're, that's a legitimate concern. So I think that's difficult, and we don't know what the exemptive relief or other things look like. And I think it's true that I'm sure Jason and Josh and Sam and others would say the same thing. As a result, we have client bases that are global, and a lot of it is projects that are outside the United States, wondering what they can do in the United States, and are often being told, no, you can't do that in the United States. And that is often the answer. And the good actors often are the ones who adhere to that, or do their best to do only what they're allowed to do in the US. But not every, it creates a perverse incentive where those most desirous of complying with the law are the least likely to reach certain US investors. That doesn't seem to be the right incentive mix. And and I also agree that people, when they're designing projects, it's one thing to try to comply and register if you think you can register, but there are real questions about, well, how can this token be used in a global ecosystem? Because this is not a US only issue. This is not something the US can solve in isolation. And if there are global markets and global interoperability and people issuing tokens on an Ethereum, ERC20 basis that will then effectively automatically be tradable on all sorts of decentralized exchanges and other things, how do you do that in a way that you can confirm will comply? And there aren't clear answers to that.
Yep.
So I think we do have to look at a way to keep this, that global picture in mind, and fold things in.
Just to jump in on,
Josh, let's go to you first, and then Sam will come to you.
Sure. Sorry, I'm as everyone on this panel knows, I'm very bad at anticipating when someone's going to stop or start talking on these panels that are virtual. So my apologies.
You have multiple litigators, so we're just all going to keep talking.
So I know I sound like a broken record about this, but I do feel that I need to say it, given what Kayvon mentioned about the hesitation of many to approach FinHub. I personally have had good experiences on behalf of clients, some of whom have gone before FinHub for literally years now. And so I can say honestly, there are positive paths forward, and it can be very instructive and useful. To date, we may not necessarily have seen tailored exemptive relief. I'm hopeful that we will have it. And I'm hopeful that maybe statements like that by Gensler might foreshadow some sort of relief.
I was going to say, to Kayvon's point about the signals and the incentives for cooperation or coming forward, I will tell you that I've had very bad experiences under the Gensler regime with cooperation, and I think I'm sure I credit Josh that there are cases where FinHub has been great, or I'm sure there are anecdotes like that, but there are also many horror stories, and I hear about it not just from my own experiences, but from colleagues, and this, if we just focus on this case, the Coinbase case announced last week, this is a case where Coinbase was cooperating, providing information to the authorities that you look at the evidence cited in these charging documents, there are Slack messages, there are other records that Coinbase must have provided to the regulators to help them make this case. And instead of being rewarded for that with a dialogue, hey, we're thinking about calling these securities, what's your position? If you look at the public statements by the chief legal officer of Coinbase and others at Coinbase, it seems like they were afforded no process in this. It used to be, there was this thing, the Seaboard report that the SEC implemented. It was a framework for cooperation. If you come in and report something and you meet the factors, then even if you had done something wrong, you would get a benefit for that. And I think the view for at least folks who do white collar defense, litigators who do white collar defense, there's real skepticism of whether there's a commitment to that framework right now under the current regime.
Sam, thank you. And I know there are audience members and participants. Please continue to submit your questions via Q&A. Panelists, let's not answer them directly in writing, and we do want to recite them out for the rest of the audience. No, it's part of the transcript as well, my friend. No, I appreciate that. Jason, let's stick with you if we could, because one of the conversations that's been happening in the crypto space broadly has been this perceived or real kind of regulator turf war. And that really kind of got exemplified in the wake of the SEC action. I think it was a commissioner at the CFTC. I think it was more than one, and I'm trying to quote here, condemned it as a, quote, striking example of regulation by enforcement. What do we make of this competing regulator commentary? And how does the industry need to adjust or understand that dynamic? Jason, you want to kick that off?
Sure. So there is overlapping jurisdiction here, at least in theory. And, we saw a little bit of snapback. It was Commissioner Pham, I believe, who posted a tweet that was directly critical. And I think it was Commissioner Johnson who had a more conciliatory statement, but still said, we all have to work together on these things, which, reading between the lines, suggested a criticism that the SEC was not working with the CFTC. Now, the core question, does the CFTC have the jurisdiction to bring these cases itself? Well, it clearly has the authority under Rules 180.1 and 180.2 promulgated under Dodd-Frank to bring insider trading actions in commodities. Now, there's a little bit of a footnote here. One can question whether it can bring it in any commodity. The way I read the CEA, it's only commodities that have a future or a derivative. I've been on a hobby horse about this for years and years. I think that you have to be very specific about the token having a derivative, but two federal courts in the Eastern District of New York, and District of Massachusetts have disagreed with me on that and said, well, Bitcoin is crypto and Bitcoin has futures, so crypto has futures, so the CFTC has jurisdiction to prosecute fraud in any crypto. I don't think that's good law, but I don't wear the black robes, and so right now it's the best state of the law. So the CFTC would, under that theory, have jurisdiction to bring an insider trading case. And the CFTC would not even have to show that these things are securities. The SEC has to make all of these allegations. It has to lay out all the Howey test factors, et cetera, et cetera. The CFTC can just say, yeah, these are commodities. We have authority, see these two cases, and move on, right? It's a much simpler task. And, I kind of wonder, I have no inside information, but I kind of wonder if the CFTC wasn't looking at this issue already and got beat to the punch by an SEC that wanted to, come out on the same day as the DOJ. No inside information about that. I have no idea. But I think the CFTC is saying, hey, wait a minute. These are commodities. These crypto tokens are commodities. that's our area. And we have jurisdiction over that in a way that we don't have to reach for it. So you should be leaving that to us. And of course, the SEC is a much larger agency. They have a larger enforcement division, more staff, more resources. So, maybe the SEC may just be in a better position to bring these actions. But just because they can doesn't mean they should, or doesn't mean that if anyone's going to, that they're the proper regulator to do so.
Jason, thanks. Appreciate that. And let's also, on that topic, something we hear in the industry a lot is, well, the reason people are pushing crypto participants to the CFTC is it's easier. You're an easier regulator to deal with. And I might be paraphrasing a little bit. I want to open that up to the group as well. That's not necessarily true, but does anyone have thoughts on that kind of industry perception? Or bluntly, legislator perception? We've heard that from some legislators as well.
Yeah, and as I mentioned on the call before, I've had folks say to us, says, oh, you're regulated by the SEC. Why don't you change your regulator to the CFTC? They're much more lenient. And of course, that for what we're doing, that's not possible. If it's, SEC stands for Securities and Exchange Commission. So if you're talking about securities or tokens that are securities, that's your regulator. I guess the differences come in I guess deciding whether something is a security or not. I think it's fair to say that the CFTC has been more forward-looking on a lot of these things.
Great, thank you all. We've got about 9 minutes left. I'd like to address the 4 or 5 remaining questions that have come in. Others, if you're bringing them in, certainly submit. If we can't answer them here, we're happy to answer them separately. And I'll share these for the entirety of the group. Marie, thank you for this. Were any or all of the tokens initially sold by the issuer in compliance with securities law? Presumably we're talking about those 9 tokens or the 25 tokens. Anyone want to take a pass at that?
Yes, all of them were. Next question.
Okay.
I think that's like opposite answers.
All righty. Go ahead, Josh.
I'm sorry. No, I can answer it more seriously. I'm sorry. I think the answer is, every lawyer's favorite 2 words. It depends, right? You have to look at all of the factors here. You have to examine whether the Howey test is met. I think for some of these, they were issued originally under valid exemptions. If you issue under a Reg D exemption, and then the question, and this goes back to what Josh and Kayvon were talking about earlier, if it was issued validly at the time, but the SEC has a beef with how it's trading now, then you're getting into all of these issues about the Hinman test, whether it can transmogrify into being not a security, into the Lewis Cohen test in separating the investment contract from the security itself. The ghost of Lewis is with us always. So we have to ask yourselves, like, maybe they were, maybe they weren't, but also, does that matter here?
Just to add, I don't think any of them, if there may have been an exemption, but I don't think any of them filed a Form D. They may have complied with that, let's say, but you would need to file a Form D as well. I don't think that happened.
Thank you all. Next question. Dean asked a really interesting question. The 9 tokens widely traded, and I didn't even think to look at this. Were they widely traded or thinly traded? And is it possible that those tokens were chosen so they wouldn't have a large impact on retail investors? I didn't even think to look at the trading volume for those tokens. And does it matter from a regulator's, from the SEC's perspective?
I can't speak to exactly how widely they're traded, but I would say the profile of the tokens varies pretty widely. I mean, some of these are tokens that people have heard of, the projects that are somewhat better known. Other ones were lesser known. There didn't seem to be a correlation there, and it's also, I mean, it's hard because we're dealing with imperfect information, because it's not just these 9. You would have to compare these 9 to the other 16. That they say there's 25 others being traded, but we didn't go after the other 16. So you'd have to know what that full list of 16 was to say, is there any distinction between the 2? And that sort of piecemeal information. This is exactly the kind of concern people have with this concept of so-called regulation by enforcement, is that we can't tell what the SEC was doing. We can't tell why these 9 tokens were. We can get a bunch of experts on a panel, and nobody can figure out exactly why the SEC chose 9 and didn't say the others are too. We just haven't gotten there yet, or the others aren't, or here are the common factors, or we drew the line this way or that way. We are all guessing at why certain projects have now been branded with the label of security and all the ancillary effects of that, and others have not. And that is the kind of thing that leads to confusion in the market. And that, all these questions that are coming up, that, that is precisely the concern people have about this approach.
Totally agree with Kayvon. And I think just, building on that, some people have said, well, hey, of the 79 tokens that were alleged in that putative class action to be securities, only one ended up on the SEC's list. Well, there are many possible reasons for that, right? Including when the tokens initially were listed. Also, whether there actually was alleged insider trading by this person and those other two individuals. So one really can't, similar to what Kayvon's saying about it's hard to draw inferences, same thing. It's hard to draw inferences as to, why these 9 versus, that much broader list that we'd heard about earlier in the year.
Great, thank you all. Let's address one more question and then give some closing thoughts to all of you. Lindsay raises a point that we addressed earlier on. The SEC reviewed Coinbase's listing processes. State regulators like DFS in New York have as well. How does this align or jive with the complaint that these are securities? And it really raises that interesting point of, and I alluded to this a little bit earlier, which is SEC says come in, and there's a whole bunch of people who are like, no, I don't want to do that. That'll be bad. What are your thoughts about expanding on that a little bit? What does the industry need to understand in the context of why it is or isn't valuable to come in and have these conversations?
Well, I think that's always a risk analysis of how the regulator will react. You've heard different views from panelists on today's panel. It's not an easy choice, and it really will depend on the case. I think to the specific question here, and the regulation by enforcement theme here, Coinbase and many exchanges do a risk-based analysis. They have bright lawyers do an analysis of whether a coin meets the Howey test. They're not just going to list something that they think could be, they don't want to be in a situation like this. So they do an analysis, and they had great people look at this. They tried their best in good faith. They thought these were not securities. They list them. And then despite that fact, a different people at the SEC can say after some months of investigating, no, in fact, these are securities. And by the way, this is a strict liability violation. So if these in fact are securities, whether you were reasonable or not, whether you knew it or not, doesn't matter, liability. And that, I think, when given the opportunity, I think everyone in the defense bar should look early and often for opportunities to present a court with the question of whether this is consistent with due process and whether we really need to have a knowledge standard, whether strict liability is appropriate in situations like this. Because if knowledge or reasonableness is a defense, then that due diligence should matter. But unfortunately, under the regime or the law, the way the law has played out right now, it's not a defense.
Sam, thanks. We've got about 2.5 minutes left. I want to open the floor to our panelists for closing comments. I know there's 1 or 2 other questions left. We can answer them separately. Sam, while the focus is on the window with you, any closing thoughts? We all have colleagues and clients on different ends of the spectrum that are getting involved. What are your thoughts about this case and going forward?
Well, first, thank you, Ron, to the Wall Street Blockchain Alliance and to my fellow panelists for having us here today. I want to pick up on a theme Jason hit. Jason talked about how the regulation by enforcement approach hurts investors. And I would go broader than that. I would say it hurts our country. It hurts the United States. This is a country that is founded on the principle of innovation. We are a place where people experiment with great things, come up with amazing technology, create jobs and opportunity. To have that, we need a regulatory regime that entrepreneurs can work in, or folks are going to go offshore, and the innovation and the jobs that come with that are going to be.
Sam, thanks. I'm going counterclockwise on my screen. Jason, over to you. Closing comments and thoughts.
20 seconds to open up a giant new can of worms.
Go for it.
In the DOJ case, unlike in the US v. Chastain, where they charged Nate Chastain of OpenSea not just with wire fraud, but also with money laundering, in this case, the government did not charge money laundering, even though the substantive allegations about using a series of addresses in order to make the exchange seemed roughly similar. And I have absolutely no idea why. I think in my view, the answer was they overcharged in Chastain and shouldn't have charged money laundering, and they appropriately did not charge it in this case. But I'd be curious for anyone else who has any thoughts on that, either panelists or later. It's just a question on my mind.
I think Jason just gave us the agenda for the next webinar, but if anyone wants to add to that, and then we'll continue going around with questions. All right, Josh, what about you? Thoughts, comments? What are the next steps? What does the industry look like going forward?
Thanks. I don't know if I know the answer to what does the industry look like going forward, but I do thank you and the panelists. And, you know, I always learn so much from everyone. I think what I would like to say at the end is I really am hopeful that we will hear from the SEC about what good paths forward look like, and that we will see some public statements or public no action relief for certain projects, just so we all know what we can do.
Josh, thanks so much. Richard, an old financial markets friend and veteran, closing thoughts. What does the industry look like going forward for you?
First of all, I'm humbled to be on this panel. As a non-lawyer here, I learned a ton, so it's very helpful for me. I hope I was able to add some value. I'm also kind of hopeful at this point, like Josh said, that we are beginning to kind of move forward to a new stage where there's more guidance, or there's exempted relief, or we get a better handle on what's going, because it's important, as Sam said, that, you know, the US continues, in the US capital markets, to continue to be the driving force here. One other thing to think about, closing thought, is that you know, the SEC is a government agency. Governments are political, and we have elections coming up in November, where you may well have a Republican House at least, and a Republican House Financial Services Committee, who is, you know, probably going to have a lot of questions around this, and I think we may see some changes coming from that.
Great, Richard. Thank you all. It's always such a privilege to moderate a panel with friends and colleagues. Really appreciate your thought leadership and your knowledge. One real quick note, Kayvon and I are working for our September 14th event on bankruptcies in the crypto space. You and I are coordinating on an agenda, but do stay tuned. That's free for members. We'll make that an open public, I believe, as well. Kayvon will sort that out. And this evening, for anyone in New York City, is the fourth Wednesday of the month, Cocktails with the WSBA. Drop us a note, info@wsba.co if you're interested. But thanks again for this great panel. We'll share the recording with members and attendees going forward. Thank you all. Have a great day.
Thank you.
Take care, everyone. Bye-bye.